Mr. Bergenholtz, are you there? You have to unmute. You're still muted.
How about now?
Go.
Thank you,
You're
Your Honor.
good.
Good morning.
This is 003-00567-2020. It's Stephen Bergenholtz versus Saida Bukhari. This hearing was set for 10:30. It is 10:33 right now. We haven't seen anything from Ms. Bukhari as far as joining this hearing. She was properly noticed of the Zoom hearing by Mr. Bergenholtz and was given the Zoom ID and the numbers and all the information she would need to join us. Also, it's my understanding that my court coordinator has tried to send her a Zoom invite, and she has apparently blocked the court from contacting her by email. And so as far as I'm concerned, we have proper notice and we're going to go ahead and go forward with this hearing. I've read your motion. I know you want something referred to the district attorney's office for perjury.
Yes, Your Honor. Good morning.
If you want something prosecuted by the DA's office, you can call them yourself and file it with them. That's not something we do. So,
Your Honor, yeah, I was informed by the DA's office that they no longer accept complaints from individuals like myself, but they would need a referral from the court, and that's why I incorporated that into my motion, not for purpose of inconveniencing the court.
Yeah, you'd have to contact the police. That's where they get the referrals from.
Okay, I'm happy to do that, Your Honor, with the ability to be able to come back and ask Your Honor for assistance if the DA's office again says because the conduct occurred in your court or by and through your court that they're the ones that mentioned I needed the referral.
Let me ask you this: what do you think she committed perjury by doing?
Well, a simple example would be she stated that she was not in possession of alcohol on the day she assaulted me, and of course there was probably six or seven police officers at the scene because of her conduct, and the body cams clearly show they found alcohol on her possession.
Hang on, where did she say that at? Where's that perjury documented?
So that's in her response to her request for admission. But I provided the DA's office had mentioned to me that I needed to incorporate an affidavit with my filing, and I outlined that in my affidavit attached to my filing. I actually go at length at a number of different responses that were perjured, not just one or two. It's called Affidavit of Stephen Bergenholtz in support of plaintiff's motion for referral to the Collin County DA's office. And in that motion, I list out, not everything, but I list out a number of different. And again, it's not one person's word against the other. There's body cam, there's multiple police officers' body cams, there's audio, etc. She even stated that she didn't assault me, but the video shows that she hit me. And it's just not my word. The police have documented witnesses as well as part of the police records and the file as well.
Right. I mean, perjury is something very different. I mean, you're involved in a lawsuit with her. She's probably not going to admit some of the things you want her to admit to. I don't know. You can talk to the police, see if they'll pursue it, but I doubt they will. So I don't know that's perjury, man. That's not something I can get involved in. I don't know.
Well, no, I'm not asking for you to make a judicial ruling if there was perjury or not. I'm merely just asking for a referral so the DA's office can make that decision.
I can't refer something to the DA's office that I don't know is perjury. You see what I'm saying? I wasn't there.
No, I understand you weren't there, but I provided an affidavit, and as I stated earlier, not to debate the merits with you, she's tested it, and I understand I appreciate your comment about not having her entrap herself, for lack of better words, but she's obligated under the rules and under her verification to state the truth. And when she doesn't state the truth and she repeatedly contradicts what reality is, that amounts to a perjurous conduct. And it's not just one or two times; it's multiple times. And she even contradicts what the police stated and what the body cams show, occurred on the day of the events. So again, I'm not asking the court today to make a ruling or decision that.
Okay. I can't refer it to the police. It's not something that occurred in my view, and if she did something in the courtroom where she actually committed perjury, and I knew for a fact it was perjury, I probably could, but the best way to go, I guess, is talk to the police, see if they will make a referral.
Yeah, I'll happily do that.
All right.
And then with the right to reserve my right to be able to come back and then put on evidence of further evidence of the conduct, if that's okay with the court.
That's fine. And what else did you need happen? And I know one thing you want is sanctions for her not responding to primarily, I guess, the request for production in some of the interrogatories. Is that right?
Well, you had ordered a motion to compel.
Right.
Your Honor, I wrote up a little something. It's also in my motion. Part of it's in my motion. I had issued, like, for example, I originally filed the case. I put in a request for disclosure. Then I sent out requests for admissions, interrogatories, and requests for production. And every which way she's refused to either comply and or fully comply without my having to come to the court for assistance. Back in July, Your Honor signed a order dated July 27th, 2020, order granting plaintiff's motion to compel defendant's responses to requests for production interrogatories, which the defendant has failed and refused to respond in any way, shape, or form. At the time, the court may recall she had counsel prior to counsel later withdrawing. There was no forthcoming response of any kind, irrespective of the, in total disrespect of the court's order and my trying to just put on a case and collect discovery. I also provided as an exhibit on July 24th, again, at the time defendant had counsel, I served a notice of intention to take a videotaped deposition of Saida Bakari, who's the defendant in the case. I properly noticed it, had it served, e-filed, and unfortunately, defendant refused to appear. I have the receipt, which I filed as part of my filing also. In that the e-filing system shows that defendant's counsel had not only received the deposition notice, but opened it on July 4th, 2020 at 12:36 p.m.,
Okay.
which was the same day.
I'm going to order sanctions, and the sanctions are going to be this. I'm going to strike all of her pleadings if she does not, by September, today's the 15th, is that a weekday? let's do it by September 15th. If she does not respond completely to all the interrogatories and the request for reduction by September 15th, all of her pleadings are going to be struck. So she will not have pleadings on file. That's the biggest sanction we can offer.
Your Honor, just so there's no misunderstanding, since the earlier discovery, I had prepared and served additional discovery on them, and they refused to to respond to any discovery whatsoever. I wrote a little something up. If I could have 2 minutes to, because it's my understanding per the Texas Supreme Court opinions and the precedent that the court has the right and ability to grant terminating sanctions at this juncture for discovery abuse, amongst other.
That's
other
what
issues.
I'm doing. I'm gonna give her a chance to actually respond to it once she gets a copy of the order, because she had a lawyer at the time when we ordered her to comply. I want her to see it herself and have a chance herself to comply, knowing that what's coming is she'll have her pleading struck.
Your Honor, how do I deal then with her not appearing for the deposition, not for responding to multiple other sets of interrogatories, requests for reduction, and requests for admissions?
She's going to have until September 15th to fully and completely answer all the requests for the interrogatories and the requests for production.
And admissions.
Admissions are deemed admitted. She didn't have to respond to those. If she didn't respond, they're automatically deemed admitted. So.
Okay. So will the full court in this order then that all unanswered requests for admissions are deemed admitted?
They're automatically deemed admitted, yes.
Okay.
And then what we'll also require is by September 15th, she have a date certain when she will give her deposition, if that's what you still want.
Yes. Well, if the case is going to proceed, Your Honor, yes, we'd of course want a date certain.
If she doesn't comply by September 15th, then she'll have her pleading struck, and I don't know what you'll need to do after that.
Okay, well, we just proceed with a default judgment, right?
Does that make sense? Yes.
Yeah, then we'll proceed with default. If she doesn't respond by the 15th, then it amounts to a default judgment, right?
Basically, yeah. She won't have responsive pleadings.
Yeah. And then I guess I effectuate the same thing as I was requesting today, the terminating sanctions.
No.
So we'll just have to give it I'll give it a few more weeks out of respect to the
we'll need an order that basically lets her know that she has until September 15th to provide complete responses to production and interrogatories and provide a date for her deposition. If all three of those things aren't done, and she needs to provide notice to the court that she has complied with all three things, then on September 15th, I will strike her pleadings.
I'm just making a note here, Your Honor. I'm sorry for looking away from the camera.
Does that make sense?
Yes, Your Honor. Yes, and so if I wanted to file a motion for summary judgment, I don't. We'll just there's no time for that anyway, so just leave this be.
Well, it's an unliquidated claim, so you'd have to prove it up in person or by Zoom.
Yeah, and I was prepared to prepare to prove it up today, but that's okay. I submitted as part of my records. If Your Honor would allow me to, I submitted my medical records, the cost as Exhibit 1 to my that was filed with the court. Not filed. I'm sorry, emailed to the court clerk under their directions. And what I'd like to do is ask Your Honor to take judicial notice not only of the file, but Plaintiff's Exhibit 1 and the medical records and billing statements therein, which contains my evidence that I'm offering. And because I don't hear an objection, I'd just like a reference on the record that they're admitted, so I don't need to do this again.
Well, they're not admitted for today. They might be admitted at a trial.
Okay,
I don't need your medical records today.
okay. Okay,
Does that make sense? I mean, all we're doing today is trying to resolve the discovery issues, and I think we have.
and then, Your Honor, what was the dollar amount for the sanctions as well? The dollar,
You're not an attorney, are you?
no, but I still got time and expenses, and she didn't appear for the deposition. So no, by no means, I'm not a,
You don't get money sanctions unless you're an attorney. We can award attorney's fees, but you're not an attorney, so you can't get attorney's fees.
okay, Your Honor. Okay, I'm not here to, that's, okay, well, I still had time and expenses, and according to my understanding, under Texas Rules Civil Procedure 215.3, in Giampoli and versus Touchy, and in other cases, but that's whatever Your Honor would like to do.
You get awarded money sanctions for your attorney's fees and court costs. But that's it. When your case is resolved, you'll get court costs. So.
Yes, Your Honor, that's right. Your Honor, I'll send an order over. I'll send it
Okay.
I'll send it to defendant. I'll email it to her. I'll send it to her as a message, but via text message, and I'll also send it to her through U.S. Postal Mail, first class mail as well.
Okay, sounds good. Anything else?
Your Honor, I believe that's it for the moment. Your Honor, just for clarification, because she didn't respond to the other discovery, I just want to make sure I do this right for you, that we're saying that she has until September 15th to respond to all interrogatories and all requests for production served upon her, correct?
And give you a date and time for her deposition.
Yes, Your Honor, I have that. All right, then.
Okay.
I'll send an order over later today, and I appreciate you. Thank you.
All right. Well, thank you.
Bye-bye.